One of every lawyer's pet peeves when we're in courtrooms is when someone who is unrepresented comes in front of the judge and we spend 30 minutes for a judge to explain to you what we're here for today or what these hearings are about. And unfortunately, those that are unrepresented, they come into the courtroom and think that every day is trial day. And that's just not true. Most of the hearings that occur in a standard personal injury case, or most civil cases for that matter, are not trial days. They are scheduling hearings or status conferences. So I'm here to break down the different types of hearings that I typically go to and what they are for, right? So when we file a lawsuit, the first hearing that we're going to get typically in LA County, and this is for LA County cases, you're going to get something that's called a CMC, or a case management conference, which the court or the judge is going to schedule in your case. And a case management conference is just a hearing where the judge may ask us what's the status of discovery, which is a phase of litigation, and whether or not we want to set this case for trial or not. Typically, in most personal injury cases, at least before they transferred everything out of the personal injury hub, during your case management conference, they're going to set a trial date and a final status conference. And that's the only thing that you're there for. If you're arguing about discovery disputes or depositions or your case in general, the judge is not going to want to hear that. They're there to set dates or to set another status conference regarding mediation, right? So that's what a CMC is. It is a case management conference. It's really just a routine hearing for the judge or the court to figure out where you are in litigation and whether or not your case is ready for trial or not, right? A mediation status conference, which is similar, is just for the judge or the court to know whether or not you were able to settle your case at mediation. So what is mediation? Mediation is a procedure where both parties decide to go to a neutral mediator who's usually a retired judge or retired attorney who has handled a lot of similar cases as yours. So if it's a slip and fall case, another type of premises liability case, or a car accident case, you're probably going to go to a mediator or a retired judge that has had a lot of experience handling those types of cases to where they could potentially get you two to settle the case at a particular number. And if you don't settle a case at a mediation, the case just keeps going forward. So at a mediation status conference, the judge wants to know if the case is settled, is it near settlement, are you close, are you far apart in your numbers? And that's the only thing the judge is going to want to know is how the mediation or how did your settlement discussions turn out. If your case doesn't resolve at a mediation status conference and the judge didn't set a trial at a CMC or a case management conference, your judge might set a trial setting conference. And that sounds just like what it is, right? It's a conference or a hearing to set your trial date. Your judge is going to want you to meet and confer with the other side, the opposing counsel, to figure out when your schedules are available for a trial and potentially how long that trial is going to be. And then the judge or the court is going to set your trial at that trial conference or your TSC, unless there's something else that your court or your judge wants you to do before setting a trial, right? Motions to compel. A motion to compel hearing is typically regarding a discovery dispute. You didn't show up for your deposition. You didn't answer some questions that were sent to you that opposing counsel is able to send to you and that you have to answer within a specific time period or before a deadline. And if you don't answer by that particular deadline, or if you don't sit for a deposition, if you're not meeting and conferring with opposing counsel about potential deposition dates, and you're just not answering them, they could file a motion to compel your deposition or further responses to discovery requests or questions that they ask of you. That type of hearing is about whether or not you had good cause to not respond or not show up for your deposition one way or another. And typically the judge is going to make a decision as to whether or not you're right or the other opposing counsel on the other side is correct about your discovery dispute. That may also include some sanctions for the time that they had to spend on the discovery dispute if the judge doesn't believe you had good reason to not comply one way or another. We typically try to avoid those hearings if we can meet and confer informally and resolve those things without having to go to motion practice. Demurrers, DEMURRER hearings. These are typically motions to dismiss your lawsuit based upon some technical error in the way that you wrote or you pled your lawsuit, which is why I would tell everyone, if you're filing a lawsuit, talk to a lawyer, get a lawyer, have them file the lawsuit for you. They're going to be able to walk you through whether or not they believe you have a good claim or not, but you have to plead or you have to write your lawsuit in a way where it's going to escape a technical motion to dismiss. And I can't go into the many different ways or the many different reasons as to why they might believe that your lawsuit is technically deficient, but it's typically a technical reason, not one necessarily based on the merits of your claim. So that's a demurrer, DEMURRER. How I explain it to my clients is that it's a technical motion to dismiss your case, right? And if you plead your lawsuit the right way or write it the right way, you can typically avoid most demurrers by opposing counsel. Motions for summary judgment or motions for summary adjudication. This is another type of motion to dismiss, but this is generally based upon the merits of your claim. Sometimes it could be technical reasons as well, but essentially they're saying based upon discovery, based upon the depositions, we don't believe that you have a viable claim. And this is typically one of the most important motions that can occur in a particular case, because you may not be able to get to a jury or to a judge to try your case if your case gets dismissed on a motion for summary judgment. So in terms of the most intensive work that goes into motions in my practice, a motion for summary judgment is typically where we're going to work up a case in order to oppose one of these that are brought by the insurance company for some reason that they believe that your case is inviolable. But this is probably one of the most important motions that can occur in a case, and one of the most important motions to fight in your case if you're a plaintiff. The last one before we get to a trial is your final status conference. So a final status conference is essentially a test for us lawyers where a judge is going to make sure that we have all of our trial documents and they are done correctly based upon the court's orders. And that generally includes jury instructions, special verdict forms, witness lists, exhibit lists, a joint statement of the case, any motions to exclude evidence or what we call motions in limine. And they all need to be in binder format, even digitally now, and to the judge's liking. Otherwise, they're going to kick that final status conference to a little bit closer to trial, and then we need to meet and confer over documents or errors in the documents, or a judge might have a particular way that they like to run their trials, and we need to make sure that all of our documents comply with the way that they like to run their trial. So that's typically what's going to happen at a final status conference. In addition, the judge is going to ask us whether or not we're actually ready to go to trial in a week or 2 weeks. And the reason why we may not be ready to go to trial in a couple of weeks or on our actual trial date is one of the experts or one of the witnesses may be unavailable. They might be on vacation. They might have another trial that they're testifying in and can't go during our week. So we need to kick the trial a week or 2 or a month out, right? So these are some of the things that we're dealing with at the final status conference. Are we actually ready to go to trial? In terms of our witnesses and in terms of our availability, not just the expert witnesses, but if I have 2 trials on the same date and one is older, I might have to take the older trial before the newer trial if they're within the same week. So are we ready to go to trial from an availability standpoint? And then number 2, have all of our documents pass this test that the court puts us through to make sure that the trial is going to run smoothly and that we filed all of our trial documents appropriately. Last but not least is the actual trial. And everyone has seen a trial either by watching Perry Mason or some Law and Order show or something of that nature, right? Where there's witness testimony, we come in, we have jury selection, we put on a case where we have opening statements, witness testimony, closing statements, and then the jury deliberates on the merits of your particular claim. So those are essentially all of the hearings, not all, most of the hearings that you're going to encounter in a standard personal injury case. There are some hearings that are a little bit, how should I say this, a little bit more rare. So I'm not going to name for you every single type of motion that could potentially be filed and why, but those are all of the hearings that I typically go to in most standard personal injury cases, with a couple that we may not have discussed here today, right?